Good morning. It is shortly before 3 o'clock a.m. on September 21st, 2021, which means by the time this video uploads, it's going to be after 3 a.m. in Texas or 4 a.m. on the East Coast. I am just going to make a notice here about reading through Article 16, Section 50 of the Texas Constitution. Has to do with considerations of an effort to extend lines of credit and to use homestead properties in connection with loans and or in exercise of some sort of lien. It's rather comprehensive and it's very important. Texas has a very specific history when it comes to homestead law. And one of the primary things to understand about homestead law is that it is about state of mind. And it is about understanding that you've made an agreement with somebody, including somebody you've allowed yourself to take into consideration as being someone you can provide for, or that is somebody that you consider to be worthy of your protection. And that person should be safe, and that it is important as an understanding of your culture and your value, including in connection with your relationship with the state of Texas. That person be protected against unwise decisions you might make, including under the influence. See, this is how I was first exposed to Texas homestead law by somebody that understood themselves to have a very long term legacy, including family legacy in the state of Texas. But then there are things that are actually codified in law and that are explicit. In order to have a homestead claim, there are actually rather minimal requirements. But in order to take a loan out on a homestead, then everybody that has a real, actual possessory, actual homestead claim has to be acknowledged and has to approve of the loan. You cannot have a homestead property where you are on site in the homestead with another person who's on site in the homestead that also has a homestead claim and use the homestead property to open a line of equity or a line of credit or a line of credit based on equity and or take out a loan in connection with using the homestead as collateral without getting consent up front from the other person involved with the homestead. My concern is that that's exactly what the state of Texas tried to gamble with in the last few years, especially in consideration of the way it's handling the alleged border crisis. Explicitly stated in the law are several things that preclude against having acknowledged any sort of loan or line of credit that is created in connection with a homestead property. But there is a specific clause within there that says that no loan or line actually under line of credit, no extension of credit can be considered valid unless the people with the homestead claim all agree up front or agree later. I know exactly what that means. You don't have a right, however, to lure somebody in, put them in a position where they understand and have had affirmed their homestead claim, and then secretly take out loans or extend lines of credit based upon their homestead claim without informing them, and lie to them when they ask you directly, do you have some other speculation going on involving the use of this homestead? And then later think you're going to engage in unlawful process in order to try to coerce them to ex post facto legitimize your illegal loan arrangement or your illegal effort to extend somebody else's credit in your name or on your behalf. There are consequences for trying to apply that kind of coercion and not succeeding. And according to Section 50, Article 16 of the Texas Constitution, that means you forfeit all expectations in regards to returns on advances, premium, or interest, including in connection with a reverse mortgage. You forfeit. And if it can be proven that anybody else you engaged that relationship with had knowledge, foreknowledge, that the arrangement was under fraudulent pretenses, I contend that also puts into consideration other real properties that they were attempting to engage in unlawful loan arrangement or extension of credit in regards to, and that they could well be in a position where they're going to have to acknowledge they've forfeited as well. Now, in terms of the exercise of some sort of judgment lien or some sort of lien connected to those arrangements, it says very explicitly in the Constitution, if it can be proven that the original arrangement was engaged through fraud, it is not binding. Period. There are many other things that this law says. I will say that there is in the actual law, in the actual specific law for the state of Texas, there's a specifically worded agreement you have to have in order to justify using a homestead property for a loan or an extension of a line of credit, including home equity credit. If you don't have that, then you leave yourself open to allegations of fraud. And if you're using some derivative process, including one involving acts of identity theft, then you open yourself up to other allegations, including other allegations of fraud. And there is a very specific reference regarding the use of a homestead in consideration of other kinds of security arrangements, including security arrangements that are negotiated in languages that are not English. If those negotiations or considerations take place in any other language besides English, then by law, you are required to have the constitutionally mandated loan agreement or agreement regarding extension of credit translated into that language as a understanding and reference that you have agreed to a loan or a credit arrangement concerning people whose first language is not English. If you don't have that and you're conducting business involved with a credit arrangement or a loan arrangement on a homestead property in Texas in any other language but English, you open yourself up to very significant accusations, including ones that may take into consideration other laws, including other laws that were officially cited in my efforts to contact the Supreme Court of Texas. This is the law. It's right there. It's very plain. There's a number of other things concerning that law that apply to people. If you have an arrangement with somebody and you discuss with them your understanding you have a homestead claim on their property, then they are required to put in writing any sort of effort to use the property on a loan or an extension of a line of credit. And if they agree in any way to allow for somebody else to be put into a position where they have any stake in the mortgage claim or the actual real property claim, then they have to get your consent and approval in writing beforehand. If they do not, they have a very specific time frame. They have to produce documentation. If they don't, they forfeit. That's the law. Now, it's important to know in the state of Texas that there's a 12-day time frame after the completion of consideration of an initial contract regarding a mortgage, which is 3 days, of an additional 12 days in order to establish whether or not that mortgage is available for any sort of credit or loan arrangement. But that means it's 15 days from the signing of the mortgage, and that makes a very big difference. There are other things. If you've made improvements, if somebody intentionally disimproves the property and then refuses to repair it for over a year, these are things that can happen to put a stake for you, but also to remove their stake as well. The major thing is, though, they have no right to lien on you without your permission. And if they go out and they hustle deals, including illegal deals where they try to invite someone on site to do something incredibly illegal, even if the cops decide that they're going to buy in and just refuse to take a police report, they can still be put in a position where they have to understand their violations of the law have forfeited their claim. And that's where we are today.